Out of here.
Here we go. There we go. Good morning. Welcome to Santa Rosa County Board of County Commissioners. It's Monday, November the 10th. And, if you would please take a moment to silence your phones so we don't interrupt each other. And if you would, please stand with me for the invocation, and then I've lost track, so Commissioner Williamson, if you'll lead us in the pledge. Father, we thank you for the privilege of coming together to decide our own matters, and I pray that you'll watch over this board, keep your hand on us. I pray that the things that we say and do will be pleasing in your sight, and we ask this in Jesus' name and for our sake. Amen. I'll start on my right with updates. Commissioner Williamson, do you have anything to add to the agenda?
Thank you, Mr. Chairman. I have no additions today.
Commissioner Salter.
Mr. Chairman, under Economic Development, I'd like to add one item, the introduction of our new Tourist Development Council Director.
All right, we'll make that item number 4 under Economic Development. Commissioner Cole.
No new items, Mr. Chairman.
Commissioner Lyncher.
Mr. Chairman, a couple things. I'd like to add on an informational item about a meeting that FWC held regarding Escribano Point, and then also administrative item about the local Restore Council. We have some renewal of appointments or new appointments coming up in December. So if we can put that on end of the administrative center, that'd be good.
Okay, sir. We'll make 21 the info and 22 the coastal, okay? Mr. Walker.
I don't have any items, Mr. Chairman. Would like just to remind everybody that our meeting Thursday will be at the Tiger Point Community Center. This will be our quarterly meeting in that facility. So we placed it on the agenda and need to be sure and remind everybody that that's where the regular meeting will be Thursday.
Mr. Andrews.
No additions.
Ms. Blaylock. Ms. Bell. Down that way. Okay. And next is the reminder. We've just heard it, but the November 13th meeting will be held at Tiger Point Community Center at 9 o'clock, and I hope we have a good crowd. Economic Development Committee, Commissioner Salter. Thank
you, Mr. Chairman. I have 4 items. First, we're honored this morning to have with us the CO of Exciting Whiting Field, Captain Matthew Coughlin, and he's here to give us an update and an overview of Whiting Field. Welcome, sir.
Well, it's always a pleasure to be here in front of the board, and it's an honor. And from Whiting, just an update real quick. About a couple weeks ago, some of you may already know this, Whiting Field was selected for the Southeast Region Installation Excellence Award. It's basically when the Navy recognizes installations that are doing an excellent job of executing their mission. What's really interesting about this time, though, is this award's been around since the 80s, and this is the very first time that Whiting Field has been recognized for that award. So it's a big deal, but I'm going to be honest, we can't do that alone. We can't do it without the community. And to be recognized at that level, and that level, what I mean by that level is these are installations for Southeast region that extend all the way from the Carolinas to Texas. And we can't do it alone, and we can't do it without the community relationship we have here in Santa Rosa County. So I'm here to thank you for that. And we have partnerships on so many levels, and that's obvious, but this is a real validation of that relationship and those partnerships. So I just want to say thank you, and that award is also an award for the community. And the next step in this whole process is we will be competing against Navy-wide, worldwide, against all other installations. And if we select at that level, and then we'll compete at the entire Department of Defense worldwide. So it's a great accomplishment, not only for the men and women of Whiting Field, but also the local community. And I just want to say thank you for that. We had a great year last year, or we're coming up on We produced 760 aviators last year, which is the most in about 12 years. And as you know, we've gone through a lot of transition with the new T-6 aircraft, and that's not easy to do. So we're getting back on track, and we're doing very well up there. So again, just some more news from White and Field. Next week, kind of give you an indicator of how we do in our partnership, not only White and Field and Santa Rosa County. Give you an example. We have a group of folks coming from the state of Louisiana. We have the chairman for federal programs for the Economic Development Council of Louisiana, and a team of about 6 people, and they're coming here to Santa Rosa County to see how we do business and see how they protect their bases and look at some of those partnerships and relationships, because frankly they don't know how to do it, and they're coming here because we're the example, and they want to learn. And so we're going to host them, and hopefully they can take something back to Louisiana with them. But just an example of our great partnership. So I just want to say thank you. And that's, pending any questions, that's the update for White and Field.
Thank you, sir. Don't tell them everything now when they get here.
Oh, I won't, no.
Any comments by the board?
Mr. Chairman,
Mr. Cole?
thank you. Captain, I just want to thank you for the hospitality out there at the fly-in. My wife and I enjoyed ourselves. It was a great tour that Captain provided for us, and just got to see some of the fine equipment that our tax dollars get to pay for. So thank you very much.
That was a great event this year. We had 30 aircraft from the fleet, and every helicopter represented not only the Navy, the Marine Corps, and the Coast Guard were there for that event. So, great event.
Skipper, as you know, speaking on behalf of this board and all the citizens of Santa Rosa County, how proud we are to be the home of Naval Air Station Whiting Field and all the men and women who serve there. Not only is it our patriotic duties to support those men and women, but Whiting Field and the expanding Whiting Field is a $1.2 billion economic driver in our county, so we appreciate everything y'all do. Thank you.
Thank you, sir.
And happy Veterans Day tomorrow.
Thank you, and happy Veterans Day to you also. Thank you.
Thank you, sir. Mr. Chairman, number 2, discussion of soliciting proposals for sale of 2-acre parcel in the Santa Rosa Industrial Park to facility location of building component manufacturer. There's backup in the background. Here again, that's 2 acres. It'd be for a 200,000 square foot building. Any questions? 20,000, I'm sorry. On mine, it had 20, and I got carried away, so it's a 20,000.
I like the 200 better.
200,000 on 2 acres, that'd be pretty good. Okay, 2 acres, 20,000 square foot building. Any questions? Hearing none, I'd like to move this to Thursday's agenda without objection.
Hearing none, it passes to Thursday.
Mr. Chairman, number 3, discussion of extending contracts with Greystone Consulting, LLC, and Barron Consulting through June 30th, 2015, in the amounts of $25,330 and $2,400 respectively for military consultant and grants administration, funded by a 2015 Florida Defense Reinvestment Grant, also known as the DRG. I think both of these individuals do a great job. You just heard a great report from Captain Coughlin on the relationship we have, and our consultants is a major part of that. Any discussion? Hearing none, I would move this to Thursday's agenda without objection.
Hearing none, it passes.
Lastly, this morning we have with us our new tourist council director from the Chattanooga, Tennessee area, Julie Morgan. Would you like to come forward, please, and let everybody see and say a few words?
Thank you, sir.
Julia, you need to push the right-hand button and make the red light come on. There you go.
Thank you. It's a pleasure to be here today, and it's an honor to have been chosen for this position to represent Santa Rosa County and lead them in the way of tourism. I'm absolutely excited to be here. Everybody I've met is very welcoming and wonderful. I've been coming here for years to vacation, so I'm really excited that it's my home now. So I welcome anytime anybody wants to come speak with me or call me. I'm always open to listening and working with the entire community. And this is absolutely, hands down, I do believe, one of the best areas in in Florida. I've been saying that for years. You've got some of the most beautiful beaches here, actually the most beautiful beaches in the Panhandle, and the northern end of this county is absolutely gorgeous. It reminds me of Tennessee. And so I just want to say thank you, and I'm thrilled to be here.
Any comments or questions from the board?
You're just welcome. We're glad to have you, and we look forward to working with you.
Thank you, sir.
Thank you, Julie.
Thank you.
Mr. Chairman, that concludes my report, other than, don't forget Veterans Day tomorrow. I know there's going to be several activities in the Milton area and down in the south end as well. Go out and thank a veteran. Thank you.
Thank you, sir. Next up is the Administrative Committee, and we have 22 items this morning. Item number 1 is discussion of the Navarre Beach lease policy. We've been struggling with this for quite some time. I've asked for the Attorney General's comments, et cetera. I'm going to ask the county attorney to lead this off, and then we'll open it up to the public.
Thank you, Mr. Chairman. You have before you, each of you, a pretty comprehensive review of the information regarding the leases on Navarre Beach. You also have a copy of the Attorney General opinion. I want to let the board know that whatever actions you take, whatever policy would be put in place would be constrained by that Attorney General opinion and the Florida Supreme Court decisions on which it's based, which says that a credit against lease fees for ad valorem taxes paid would be an unconstitutional tax exemption. Therefore, there cannot be a dollar-for-dollar credit, or the policy that we've had in place since 2001 would not meet muster under the Florida Constitution. So that policy has been suspended and, in my opinion, could not be reinstated. The county is also constrained by the provisions of Florida Statutes 125.35, which deals with the sale or lease of county-owned property. If you look back or think back to item 2 on the agenda, in which you were selling 2 acres in the industrial park to an industry that we have targeted and have actually given incentives to, there is a process that you have to go through to sell that property, which requires public notice and an opportunity for it to be sold to the highest bidder. That type of policy applies as well in the leasing of real property. And while we can have a policy that differs from the notice and bid process, it has to be allow for the establishment of competition and qualification standards, reasonable public notice of the intent to consider the disposition of the property, identification of the form and manner which the interested person may acquire the property, and negotiations procedures established. So it's not a situation that the commission has unbridled discretion in regard to the disposition of any county-owned real property. It has to meet those requirements of notice and competition. Now, there are provisions in some of the leases out there that can be reviewed on a case-by-case basis, and I think that there is clearly some issues of equity and that there is a great disparity in the leases out there, in the terms of the leases. Now, many of the leases have nominal lease fees. If you look at the breakdown of the 2013 active leases, the lowest fixed lease is $87.50. The average on the fixed lease is $294. The ad valorem varies also. It is important to look at the vast majority of the leases are a variable lease, and the variable lease is based on a percentage of the sales price or the assessed value of the property. And those leases that have been entered into since 2001, when the improvements were placed on the tax roll, have built into them the effect of paying those lease fees. The leases have been entered into since 2006, when the land went on the tax roll, have built into them the fact that the purchaser knew that they were going to be paying taxes on both the improvements and the land. So I don't have a broad brush or simple solution that I can recommend to the board at this time. I think that there ought to be some analysis given. Certainly, I think that the county recognizes that there are some circumstances in which the terms of the leases may, as they're interpreted, be unfair, but that's something we're going to have to look at more on a case-by-case basis, I think. The other issue, I think, is that even after credits for the lease fees, which we're not able to give based on the Attorney General opinion, there was a $995,557 net payment to the county in 2014. If these leases were somehow forgiven, or if that money was taken off the books, it would have to be either we'd have to spend $995,000 less, or we'd have to raise revenue in some other fashion to meet that demand of the budget. I'll be happy to answer any questions.
Gentlemen, anything of the attorney before we open it up to public discussion? Yes, sir.
Roy, through the chair to the county attorney. Roy, is there a time period you feel like you could come up with a, as you call it, a broad brush? You said you didn't have one now, but do you feel like there would be in a reasonable length of time a way to come up with that?
Well, I've had some discussion with Commissioner Salter, who is as the incoming chairman, if he is the incoming chairman, has requested that we have a workshop in the January timeframe to deal with some long-term issues with the county, including this one. And I think that that's something that can be give us a little bit more time to look at this issue and perhaps come up with some recommendations. I mean, we have to meet the requirements of the Constitution and the statutes. Past that point, it's a decision for the board to make, as long as we can make it in a fashion that won't be in violation of Florida law.
Okay, and the other thing, if that can't be accomplished, do you have a pretty good idea, as you said, the ones that are not as equitable as some of them? Do you have kind of like a tick list of those where you'd start at the top and work our way down?
I think we can break those down. If you look, on the commercial side, the most revenue is generated by WANAs, and actually that lease is not a lease, it's a management agreement, and that entity doesn't pay ad valorem taxes at this point. So that largest amount of funding under the commercial leases is not being subject to ad valorem taxes at this time. I think that the property appraiser's office is looking at that. But I mean, there are those issues that are going to have to need a little bit more study and more information for the board to be able to make a reasonable decision, I think.
Okay. Thank you.
Anybody from the public wish to speak to this issue? Yes. Name and address for the record, please. Step forward, make sure the red light's on. If you hit the right-hand half of that button, there you go.
Okay. Thank you, Mr. Chairman. My name is John Connell. I'm an attorney with Becker and Polyakoff in Fort Walton Beach. I represent the Summerwind condominium entities. There are three of them, the Summerwind, Summerwind West, and the Inn at Summerwind. We are here to ask you today to leave the lease payment policy in effect, at least until such time as there can be some dialogue about what the resolution is to be. This, what the county attorney is asking for, just the strict abolishment of the lease payment policy, would work an extremely harsh result on my clients. It would effectively double what they're paying. It is not fair, it's not legal, and we ask you to leave it in place. Now, I want to give you a little bit about the history of this, because we've been here before and talking about the same issue. In 1998, this lease that that involved the Summerwind entities was renegotiated. The owner, or the lessee of that lease was Sundial Navarre, a developer. And when the renegotiation was entered into, the developer agreed that the lease payment fee would be the equivalent of what ad valorem tax would be on the property. Now, in 1998, there was no ad valorem tax being levied or collected on this property, and there was no reason for anybody to think that it ever would be. And there were affidavits that we filed at the last time this issue arose from Mike Mead, the developer's attorney, and from Mr. Dunkel, saying that this, that it was understood that this lease was negotiated on the assumption that there would be no ad valorem taxes ever levied. And it's just common sense that that was the understanding, because the lease payment under that lease was equivalent to ad valorem tax. No one would have entered into an agreement, a lease agreement, that could have doubled overnight the amount of the lease payment had the county decided to suddenly impose ad valorem tax. So that was clearly the understanding. In addition to that, the developer, as a part of these negotiations, agreed to make certain improvements, which the developer made, and those include a 200-foot pier extension, adding freshwater lighting to the beach, trash receptacles, architectural theme, paved public parking, public beach access walkway, restrooms, pier store, and as a part of that, a rent payment equivalent to the ad valorem tax. So the developer and subsequently the owners of the Summerwind entities kept their end of the bargain. And now the county wants to come back and effectively, if you revoke this policy, it would double the amount that they're paying, and it would not recognize the commitment that was made in '78 when this agreement was entered into. I don't think there is any Attorney General opinion that says that this lease payment policy cannot be continued. Now, I think what Mr. Andrews referred to, if I'm correct, is an opinion of October 1, 2014 from Pam Bondi that he requested. And this is what it says. It says, this office has no authority to review and comment on the validity of local legislation or policy. So there's no opinion that directly addresses the legality or non-legality of this lease payment policy. Furthermore, there are at least 2 appellate court cases in Florida that suggest that this policy is completely legal and valid. Williams v. Jones, 326 Southern 2nd, 425, and Archer v. Marshall, 355 Southern 2nd, 781. In that case, the Florida Supreme Court noted that leaseholders in the situation that the Summerwinds unit owners are in now, and I quote, may very well be entitled in a proper forum to seek an equitable adjustment of their rental payments, which would recognize any proven charge incorporated therein which was intended to be in lieu of taxes. This is a lease that set the lease payment at an amount which was to be in lieu of taxes. And we would be entitled, we believe, to an equitable adjustment if this policy is suddenly suspended. We asked the Commission to keep the policy in place. Also, I'm not clear about whether I don't understand that this Commission has actually voted to revoke the policy. I know that some of our owners have gotten bills for the lease fee. In the past, it had always indicated that your tax payment is a credit against this bill, and that notice was not on the bills. So I'm not clear as to what the county's position is. I don't think there's been any vote by this Commission to abandon that policy. So I think we need to clarify that it is still in place until you act if that is the case.
This
And it-
board's taken no action.
That the
No
board
for-
took
no for-
action to suspend it. The board took action to suspend the lease policy at the last board meeting.
Okay, well, we were not aware of that, and the materials in the agenda didn't indicate that, at least I don't recall seeing it. We would ask that you reimpose that policy. We were not here, we didn't know about that, and we would ask that that be reimposed, at least until we have a chance to have some dialogue about how we're going to resolve this.
I think that there is a recognition that the summer winds circumstances are unique in in regard to the leases on the beach, and that is something that could be discussed. The policy was suspended because the tax bills were going out, and the lease bills were going out, and we didn't want to mislead somebody that the lease credit was still in effect. I think that this is something that can be discussed with staff and with the commission in the future, and that there can be a recognition that there is a unique situation in regard to the ad valorem being the basis for the lease fee. You are the only entity out there that I'm aware of that has that specific fact circumstance.
That's my understanding, too, that there are no other entities other than the summer wind entities that have this type of lease where the payment is tied to what ad valorem tax would be.
That's my understanding.
Mr. Chairman.
Yes, sir.
Mr. Connell, I just want to make sure that everybody, you read a portion of that Attorney General's letter, and for the benefit of people who haven't, I want to make sure that people understand why we took the action that we did to suspend that policy. And they do say this office has no authority to review and comment on the validity of local legislation or policy. But then the next paragraph says, in addition, this office addressed a similar question in AG Opinion 2008-43, and in light of the recent Florida Supreme Court case of Accardo v. Brown would suggest that the discussion and conclusion therein are equally applicable to the situation you present. As AGO 2008-43 states, while the authority may characterize this payment as an offset of lease fees, the reduction in those fees has the effect of a tax exemption and as such is unconstitutional. That is the basis that we used for suspending the policy.
I understand, but I would say that, first of all, the Accardo v. Brown case did not deal with this issue. It validated the county's right to impose ad valorem taxes, but it didn't talk about
It specifically dealt with the issue as to whether or not it was equitable or legal, not equitable, let's say, to have a lease fee and a ad valorem tax. Made the distinction that the lease fee was for the usage of the land and the taxes was for general governmental purposes.
Well, that's true, but it did not address a lease based upon ad valorem taxes, and furthermore, I think that's a dicta. I mean, I think the point of the case was that you can impose the ad valorem tax, and it's different from a lease fee. True. But I don't think that the lease fee was directly an issue in that case. That was an ad valorem tax case decision, validating the county's right to impose ad valorem tax.
And I represented the property appraiser in that decision. So,
Yes, sir.
Mr. Connell, this board, I think, we've had summer wind in mind through this whole process. We know that is the lease fee that exists out there at summer wind is probably the most striking example of why we tried to pursue a lease offset. And we're still doing that. We are not giving up on bringing some relief to summer wind and any inequitable leases out there. We just want to make sure that we do it right, and that's why we asked for the Attorney General's opinion back at the end of the summer in anticipation of a complete offset. So I think we're going to get there. It's just a matter of making sure that we get there in a manner that is legal and constitutional and fair to everyone involved.
In the meantime, what should the leaseholders do with the bill they've gotten?
Based on the Attorney General's opinion, we suspended the lease credit policy. So that's where we are now. The leases are out there, the lease fees are out there. We cannot authorize an offset or a credit at this point.
Obviously, I respectfully disagree with that. I think you do have authority to do that, but I understand your position. Any other questions of me?
Commissioner Cole?
Yes.
Thank you, Mr. Chairman. Through the chair to county attorney, the lease fee prior to this, I think, 1998 agreement to equalize it to what ad valorem would be, do we have the amount of that at that time?
I don't have that information at this point.
And would it be within the purview of this Board of Commissioners to reduce that lease fee to the amount prior to 98?
I think that the 98 lease took place before the construction of the condominiums. So it's, we're talking about vastly different circumstances for the lease payment prior to the construction of those 3 condominium structures. We could certainly look at what was in place, and I think that a direction for the board going forward is to try to reconcile the vast differences between the leases that are in place at this point. We can't negotiate an increase in the leases. So those folks that have nominal lease fees going forward are going to be entitled to pay those nominal lease fees. But if there are circumstances where it's inequitable and where there are estoppel issues, which might well take place in the Summerwind's unique circumstance, we can certainly look at that, and we can look at other fact circumstances that give a public purpose to a lease modification.
In your opinion, would the prior to 98 lease amount be considered a nominal amount?
I don't know what it was, but if it's on property that is not improved by 3 condominium structures, and there are now 3 condominium structures, I don't think that there's it's certainly not apples and apples. So, I mean, we can look at that, and that can be a matter for determination by the board, but I don't think it would be controlling as far as a decision before the board to make.
Thank you.
Any other questions?
Commissioner Williamson?
Thank you, Mr. Chairman. Mr. Attorney, I just want to make sure that I've heard that right. So basically, we could set an amount, people that were in the lease that are at a set amount, they would pay that lower amount, but we could have a maximum figure as far as the lease fee?
Well, we can look at what we can do equitably in regard to the leaseholders on Navarre Beach, keeping in mind that the board has a fiduciary obligation to the citizens of Santa Rosa County when it's dealing with Santa Rosa County property that's constrained by the provisions of the Constitution and Florida statutes. So you don't have unbridled discretion in regard to doing in certain circumstances, and circumstances such as this unique case. I think we've got a strong public policy rationale. In other circumstances, it's going to be, I mean, it's just not a simple issue. You have a lot of different, you have a lot of different fact circumstances out there that need to be considered.
And whenever fee simple title was being spoken about on Navarre Beach, I had been in contact with Ed Graber pretty regularly, weekly. I know that they were kind of what Washington was waiting for the election. Has anybody spoken with him since the election to fill him out on anything as far as moving forward? Is this something that's going to be hot on their topic, or is it back to the background again?
I mean, I talked to Mr. Graber last week, I believe it was, towards the end of the week, and I mean, they were still, I mean, based on the situation in Washington, I mean, I don't think they know what they're going to do as far as any kind of particularly a lame duck session or anything like that. I do think that there is the recognition of the inequity that Mr. Connell's talking about, and I think they do understand that the fee simple title would correct that. I mean, I think it's going to be lumped in with a number of other federal initiatives, so that I think the effort will be after the first of the year to try to pursue that through Congressman Miller and Senator Rubio proceed in that regard. But again, I don't know how the short-term fix for Mr. Connell and Summer Wind.
Thank you, Mr. Chairman.
Thank you, sir.
Mr. Chairman, if I have one more second.
Yes, sir.
When we were here several years ago, most of the owners at Summer Wind had indicated that they would agree or had actually proposed to set the lease fee at $250, which is basically the equivalent of what the other similar properties, high-rise condominium towers, are paying. And I can't speak for every single individual owner, but substantially all of the owners, I believe, would agree to sign a new lease on those terms, and I think that would be, fair. I would also ask that, we're here ready to have a dialogue whenever you gentlemen you desire to do so. I stand ready to meet with whoever to discuss this and try to work out a resolution. Just let us know. And finally, we would again ask that at least as to the Summer Wind entities, that this suspension of the lease payment policy be put on hold until we have time to work out a resolution, so that my clients will know, do we pay or do we not? Thank you.
Mr. Chairman?
Yes, sir, Commissioner Cole.
Through the chair again to Mr. Andrews. If fee simple title was all of a sudden in a month applied to this piece of property, the amount of money you talked about that we would see is going to go away anyway, right? So as a board and as a county, we need to start making perhaps plans on that if we're serious about pushing this fee simple title through.
I think that's correct. I mean, whatever action is taken by the Congress in regard to the property out there would supersede this board's authority. Yeah. What that legislation is going to actually read as it goes through, I don't know. I mean, the model was, I guess, perhaps the Okaloosa Island issues, and in that circumstance, it was pretty much an election of the leaseholder, potential landholder, as to whether or not they wanted to take fee simple title or not. And there were some fees and transfer costs and that sort of stuff that were involved. So whatever the Congress does, you're not going to be able to change, sure. But we don't know what that's going to be as of yet. If they just give the property away, yeah, the $995,000 would be out of our budget. So that is something that we'd have to consider.
Right. And then the comment about the $250 lease fee per unit, making that more equitable to the comparison properties. Would that be something that, it seems to me, just sitting here listening to this, that'd be a good, quick fix for this board to work with these people, since it is so inequitable in what they have. Do we have any reason as to why we wouldn't want to consider that?
Well, I think we want to take a look at the facts and see what, again, we'd be looking for equity out there, and whether it's $250 or $350, I don't know at this point, okay. or $125. But it's something that we can certainly consider in a matter of resolution.
Okay, and I would assume that you need direction from this board to go that way, to look into.
Certainly, I'd be happy to talk to Mr. Connell at any time.
Mr. Chairman, if I can get an opinion from the rest of the board, I'd like to give the county attorney direction to look at that as an equitable solution to this for the Summer Winds condominium.
I think everybody in this room understands this is a very complex problem that is hasn't been addressed, and it's here now. And there's not going to be a simple solution to it. And there's all sorts of lumps and bumps in this thing.
Well, we gotta get started
And we're gonna need to get a schedule, a workshop, or some sort of a schedule, a point to start. And this seems to be as good a point as any, is to start here. And then, as we move through it, see, probably progress to public hearings, et cetera. But it really has to be, we need to put our arms around this.
Mr. Chairman,
Yes, sir.
I agree with you and what Commissioner Lynch said. We suspended the lease fee credit policy because of the Attorney General's ruling. We can debate why that is, but that's why we did what we did. I'd hate to see us start trying to make decisions now without putting more thought into exactly what we can legally, fairly, and constitutionally do. So my position is going to be continue to gather information, and hopefully we'll have that workshop around the middle of January, not only to address this issue, but some other big issues facing the county as well. So that'd be my position.
The last time we were here, these are the lease payment fees of similar situated condominiums on Navarre Beach. Beach Colony 1 and 2, they pay $250. That's according to my information, and I don't think that's changed. Pearl of Navarre, $250. Caribbean Resort, $250. Navarre Towers, $250. Belle Mere, $250. Navarre Regency, $250. So there's, that seems to be a good number to work with, and I hope we can, get to that point. Thank you.
Thank you.
Mr. Chairman.
Yes, sir, Commissioner.
And I agree with what Commissioner Salter said. It is a complex issue that we need to start working towards, but would we not want to at least, for that January workshop to have staff come up with at $250 per lease fee what that figure would be, so we can see the difference between that and the $997, so we have true numbers to work with.
That seems to be a good point of departure to me. With Ms. Bell and Mr. Andrews, because it's everything we do is going to affect what Ms. Bell does for a living. I think what we need to do is to formulate a statement from the board to give the county attorney the direction to begin to put this together, working with the budget director, and suggest a point of departure for us. Anything else from the commission, Commissioner Cole?
Mr. Chairman, I guess I'll put it in form of motion that we start with this most unequitable situation, get that straightened out and make it equitable with the other condominiums, and then work from there. And I'll make that in the form of motion, either put it to Thursday for a vote, that we direct the staff.
Right. I think that's what we need to do is to get something put together today to give the staff the authority to begin to plow through that. We've got a couple of comments on the floor before we finalize this. Yes, ma'am, Ms. Mahout.
Wallace Mahout, 5500 Cox Road, Milton, Florida. I wanted to read you something straight from the Florida Attorney General's website. It says, opinions of the Attorney General are not law. They are advisory only and are not binding in a court of law. Attorney General opinions are intended to address only questions of law, not questions of fact, mixed questions of fact and law, or questions of executive, legislative, or administrative policy. So if you're basing your current decision on the Attorney General opinion, I think you need to proceed to the courts. By law, the Attorney General is obligated to answer you. So she had to give you at least what she had. And as far as the Attorney General opinion, AGO 2008-43, it says, it is fundamentally unfair for the legislature to statutorily manipulate assessment standards and criteria to favor certain taxpayers over others. And then I would say, is it also unfair for the legislature to statutorily manipulate assessment standards and criteria to burden certain taxpayers over others. Section 196.1997 provides that property which is originally leased for 100 years or more should be deemed to be owned. As far as I understand, the Navarre leases are 99 years, correct? Then this is a manipulation of this statute in my eyes. This statute says 100 years, not 99 years. And as far as needing to exclude the leases as a 99-year lease, established government ownership of the land. When Escambia County got involved and forwarded this land to Santa Rosa County, it was government land. It was never to be anything else but government land. And I think you need to take a look at this and make sure you know what you're talking about, and look at this statute and look how this land was conveyed. It was never meant to be conveyed in a manner that the county is now looking at placing more taxes on top of lease fees. So I suggest you go to a higher court and look at all the facts. Thank you.
The Florida Supreme Court looked at those issues in the Accardo versus Brown case and determined that it was proper to assess ad valorem taxes.
Yes, ma'am. Name and address for the record. If you'll push the right-hand half of that button. There you go.
Hi, my name is Pam Wingate. I'm the president of the Enid Summerwin Association. And I want to make it very clear, the lawsuit, the Accardo and versus Brown, the Summerwin Resort did not participate in that lawsuit, period. None of our owners did, and our associations did not participate in that lawsuit. And I'm here to ask the county commission again, looking over the other condominiums that are very comparable to us, oceanfront, Gulffront, 250 is not unreasonable for us to ask you to impose as a lease fee for us. I mean, right now, if we go ahead and pay, we're double taxed because our land lease fee's out there and our ad valorem tax is out there. In the past 14 years, we've been allowed to pay the ad valorem and accept the credit on the land lease. So right now, we're trying to negotiate with the county commission. We would like to propose that you consider the $250 land lease fee to make us equal to the other associations on the beach. I don't think we'll have any problem. I don't know how we'll go about this, but I'm sure each individual owner would have to agree and come in and sign off with the county on this. Basically, I want to affirm that we weren't involved in that suit. We're just trying to seek an equitable solution for our owners so we're not putting ourselves out of the market and basically seeing a lot of foreclosures that are finally ending out at our place. So please, thank you, and I appreciate you listening to me.
Thank you, ma'am. Anybody else have anything they'd like to add?
Hi, I'm Stephanie Lanston, and I'm the president of the Summerwinds West Condo Board. And we were here 4 or 5 years ago, and I stood up here, and they dismissed it and said to us, y'all may never hear from us again. Well, we're back. So just, I guess this week, I got my tax notice that was $3,337, and then I got a lease fee that was $3,036. So what I'm understanding is now I will be required to pay this year $6,373.01 on something that was probably valued around $350,000. I live in a home that's much more than this in Birmingham, and my taxes are a third of this. What this is doing is it's putting us in a bad bind. I mean, who in their right mind wants to pay $6,000 a year in taxes? And for these people trying to sell, it's going to stagnate Summer Winds Resort. And I guess I wish that this had been waited to vote on after this had been thought through, instead of hitting us with this kind of bill. And it may be just for 1 year, but 1 year affects us. It doesn't affect anyone else but Summer Winds West, this kind of money. So I would ask the commissioners vote to at least just do the $250 this year and then relook at it, instead of hitting us with this kind of tax bill. So anyway, if y'all could just talk about this and let's try to find an equitable solution to this, I would greatly appreciate it. Thank you.
Thank you, ma'am.
Ira Mae Bruce, 7189 Wells Avenue, Navarre, Florida. My dad was one of the first people to lease a piece of property at Navarre Beach. We enjoyed that home until the hurricanes blew it away. And now there's a threeplex on it. But my point was there that I've been involved in Navarre Beach since I baked the beans when the bridge was open. I've been there for a long time. It seems to have always been a point that for money, and I don't think that you guys did this. This is something with this lawsuit that was not settled. But the thing with me is that when you look at what the taxes are, you also need to look at how much money Navarre Beach brings into Santa Rosa County through tourism. We have the largest tourism in Santa Rosa County, and we would have no tourism if these taxes become the way that they're suggested. And if anybody gets greedy and thinks, well, they did it at this project, why don't we do it the other projects? Why don't we just double everybody's taxes? It's just not fair. We shouldn't be paying lease fees and paying taxes. And if we're going to pay lease fees separate than taxes, I would suggest that those lease fees be set aside for improvements at Navarre Beach, possibly beach renourishment or whatever they are. We're paying enough taxes, and we should be treated like every other citizen in Navarre, in Santa Rosa County. We should be paid what they pay and throw out this. At one time, W.D. Childers had a bill that was passed in the Florida Senate and House that if the lease fee was, if the lease was 100 years, there was no lease fees. There were no taxes. You paid lease fees and no taxes. Well, that was several years. We had taxes from Escambia County for a while, and by that one action, it took away the taxes. Once somebody else came into office and Escambia County had more pull, they got it changed back to 100 years. And until Bo Johnson became represented us, and he was able to have Navarre Beach be in Santa Rosa County. We transferred the county line at that time. We need our legislative delegation, and we need some history here because we're being played 1 year by one delegation, another year by another delegation. Whatever we do needs to be equitable. We need to pay the same thing everybody else does, and everybody at the beach is behind you in fighting this. I'm not sure whether we have the right attorney to represent us on this. And the only reason I say that is because Roy was representing the other side, and now he's switched sides, and I'm not sure where he is. And Roy, this is nothing against you. We just don't know where you are in this battle. You led the battle to do this. Now you're going to lead the battle to keep it the way it is. And I'm not sure that maybe he should be not be the attorney that works for the county in settling this issue, and I appreciate that. Thank you. And I love you, Roy.
Thank you, but if somebody can point out, any attorney can point out the other side, I'd be happy to hear it. I'm not sure there's another side. I mean, the law is, in my opinion, as I've stated it, but I'd certainly be interested to hear from other interested parties.
Linda Coley, 8271 Gulf Boulevard. I'm the president of Navarre Beach Leaseholders and Residents Association. Chairman Melvin, I would like to address Mr. Andrews with a question, if you don't mind. Mr. Andrews, I've heard you say several times in court proceedings that the leaseholders of Navarre Beach enjoy the rights and privileges of ownership. So now we are paying taxes without a title to this property. Now you are saying that we pay lease fees. So I don't understand how we can actually own a piece of property and lease it. So can you explain that to me in layman's terms?
I can try. The language is set forth in the Accardo versus Brown decision of the Florida Supreme Court, which I do not have in front of me, so I can't do it verbatim. But essentially it states that the lease fees are for the forbearance of other folks having the possession of that property. They're essentially to keep me from being able to come in and eat breakfast at your table because that's your property and you pay a lease fee for that. And the taxes are for general governmental services so that you pay for the provision of police protection, infrastructure, roads, all those other things that the people on the mainland pay the same taxes for. So, and that was not my determination. Obviously, I took that position, but that was the determination of the unanimous Florida Supreme Court. And they set forth specifically in their reasoning the distinction between lease fees and taxes, and that they were both valid assessments on your property, their opinion.
But actually, this property that we're talking about belongs to the county.
The county has bare, naked, legal title to the property, subject to your 99-year lease plus additional rentals, plus an additional 99-year term, plus further renewals on the same terms and conditions, which has been determined by the First District Court of Appeal of Florida and the Florida Supreme Court to be a perpetual lease. So if you have the right to lease it, to occupy it forever, it is the equivalent of ownership for ad valorem tax purposes. That's the decision of the Florida Supreme Court.
Okay. Well, also, I've heard you say that ad valorem taxes is a fairness issue. So what is fair about having to pay both taxes and lease fees? Where does fair come in on this?
Well, ma'am, I don't know that the fairness issue was my statement. That probably would have been Mr. Brown, who was my client. And I can only tell you what the decision of the Supreme Court was, and that is as I've expressed it.
Commissioner Blanchard.
Thank you, Mr. Chairman. We acknowledge there are fairness issues here. We're working towards them. We're just not prepared today to resolve all of these issues. I think this board is committed to coming up with a solution that is fair to Summer Winds. We've said that all along. We haven't changed direction on that. It's just not something that we can handle today. We have to have our county attorney review the existing leases out there, not just Summer Winds, but the others as well. We have to come up with a valid public policy that allows us to reduce these lease fees, because right now, like it or not, based on the Florida Supreme Court, there is a tax that is imposed, there is a lease fee that is imposed. the county will be relinquishing a legal right. We have the right to collect those lease fees at this point. We have to have a valid public purpose in order to basically waive that right. We're going to reduce those lease fees. We can't just reduce the lease fees because we feel like it or because we don't think it's fair. We have to come up and document the reasons that we're reducing your lease fees so there is a valid public policy that is served by the reduction. Because the five of us have a fiduciary obligation to the citizens of Santa Rosa County. And Santa Rosa County right now has the legal right to collect those lease fees. We're trying to come up with a solution that's fair to Summer Winds. And I think every member of this board is committed to that. And we're going to continue to work towards that over the coming months. We have a workshop in January. Hopefully we'll have it resolved by first part of the year.
Okay. But I do want you to realize that there are many other people, not just Summer Winds, that are having to pay huge, like one of my neighbors pays $1,500 taxes and $1,500 lease fees. So there's others that are involved in this. Thank you very much.
Thank you, ma'am.
I'm May Stinson, 721 Pensacola Beach Boulevard, Pensacola Beach. I am an owner at Inn of Summerwind and also an owner at Caribbean Resort. First, I have a question. Is the lease fee a usage fee or is it a tax?
It is a lease fee. It is not a tax.
All right, so then I'm confused. The Attorney General's opinion says that you cannot institute a tax credit. Now, I have a tax bill at Summerwind, and I have a lease fee, usage fee bill, and your previous actions were to grant me relief on the lease fee bill, which is not a tax. So I don't understand why you could suspend the lease fee policy when it really isn't a tax and therefore shouldn't be covered by the Attorney General's opinion.
We just have to go off what the Attorney General says. And the Attorney General's opinion and the Supreme Court cases found that this was an unconstitutional, acted as an unconstitutional exemption from tax.
Right, but the lease fee is not a tax, and therefore it's not an exemption of my tax, and my property tax is, in fact, at the proper millage rate for the property. So I have a confusion about that. So I wish you would think about that, consider that. The other thing I wanted to talk about is I am a real estate agent, and I was selling property on Navarre Beach in 1998 when this lease renegotiation occurred. And I'm not sure that I'm correct, but my understanding of why the whole thing was renegotiated was that that parcel in the master plan was designated for hotel use, not for residential multifamily. And that was the reason why the county renegotiated to use a tax rate for lease fee, because they were giving up the tax revenue they would get from a hotel versus a condominium. So it's not like this was just a condominium project where there was a renegotiation of the lease. It was in fact intended to deal with the fact that it should have been a hotel. And, you know, I could be wrong about that, but that's my recollection of it. All right, thank you.
Thank you, ma'am.
Andrea McDermott, 8093 Sleepy Bay Boulevard, Navarre. I manage several homeowners and condo associations on Navarre Beach, and so I get a view of this from different properties and the value of the lease fee from the different properties. I agree it's a mess. The way that it was done in the past was not equitable. I believe it should be made equitable. But until you come up with that policy, I believe you should remain with the policy that you have that was restated, it was from 2001 and restated in 2010, that gives them a credit. But I also believe you should do that not just for condominiums. I believe you should do it for homeowners associations, one of the homeowners associations I have are currently building over $20 million in houses. This is money that's going to come into your tax base once these houses are completed and sold. If we have this crazy policy where everybody pays something different, these houses aren't going to be valued as much, and you may even get more than the $20 million that's projected. So I ask that until you make a decision, that you hold steady where you're at and where you have been. Let's have these meetings. I believe that's a great idea so that we can get an equitable solution throughout the beach. Because when I researched this in 2010, and Mr. Andrews, I did go and look at the microfiche over in Escambia County. I'm probably one of the few who's seen it. I did understand that it is allowed that the commissioners of Santa Rosa County set the lease fees. And as long as both sides are willing to negotiate a change in the lease fee, it's allowed. That's my non-legal opinion. I'm not a lawyer, Mr. Andrews, but I do hire a lot of them. Thank you.
Mr. Chairman,
Commissioner Williamson.
when are the lease fees due? Or are they due at the same time that ad valorem tax?
It depends on the lease. They vary based on the provisions of each of the leases.
So each lease, I mean, every single lease is going to be due at a different date, the
Well,
end of
I
that
mean,
month, or the exact date?
It depends on when the lease was entered into and the term of that lease. So they do vary. I mean, it's not due on January 1 or November 1. It's based on the language of the specific lease.
So on the bill that was received for ad valorem taxes, they also have the lease for the upcoming year? Is that the way that the billing from the county works?
You know, I'm not 100% sure of that. If they do, it would just be essentially a courtesy to the leaseholder. But the taxes are due as by statute, but the leases are due based on that specific lease.
Okay.
Yeah.
What I'm moving towards or thinking about, because fairness issue, I think that probably some of the commissioners have talked a little bit about that, and you have ad valorem taxes due, you pay your taxes, then the lease fee that you also have, this lady that came and spoke has $3,000 and then another $3,000 in lease fees, which off the top of my head seems very unfair. Is there a way, if we keep pushing this down the road, I think we need to have a workshop where we commit a lot of time to this. But is January too late for some of these people where they're going to then pay, she's going to pay her $3,000 taxes, she's going to pay her $3,000 in lease fees, and then in March we're going to come back and say, we've cut the fees down to $250 or $500 or whatever it is. She's already paid $3,000. She's not going to get a credit back or anything. So is there anything that we can do as far as the lease fees, give them an extension or anything until we resolve this issue?
I think that we could do that in regard to the Summer Winds condominium particularly. And I don't know when their lease fees are due. The ad valorem taxes, of course, are not really due until May. But if you pay them early, you get your discount. So, but I could look at the terms of each of the Summer Winds leases, and it could be an expression of the council that they would, of the commission, that they would want to delay the collection of those lease fees until a final determination is made.
Does anybody else on the board have any comments about that or?
I think that's a fair resolution at this point. That way, there's no deadline in place. We're going to resolve it once and for all, hopefully within the next few months. But this would, everybody has breathing room. The bills have already come out. We'll just delay the payment due date until such time as it gets resolved.
Well, that's an excellent point. It's an excellent point, but where are we going to do that? What's the timing of that? Does that need to be done now as part of this process? It seems to me that's pretty close to step one. What's
Mr. Chairman?
Yes, Mike.
If I might, I was going to add that as a caveat to my motion, that we suspend it until that amount can be set. So we're right on cue with where I was thinking.
And we can do that. That could be the action if the board chooses, the action that you would take Thursday, because remember, all you're doing is talking about the action for Thursday's regular meeting agenda, but that certainly could be part of it. I mean, if we can at least suspend the collection of that based on some kind of future action, that seems reasonable to me.
There's nothing that would preclude the county from doing that. I've been handed one of their statements apparently, and the ad valorem tax statement is clear. I mean, statutorily, that can't have anything other than the ad valorem taxes and non-ad valorem tax assessment, which on Navarre Beach is the fire impact. They get a separate bill, or at least this person got a separate bill for his lease fees that indicate that they're due 30 days thereafter,
Yeah.
but that's something that could be suspended by the board.
That's all I want to say. They were due in 30 days, and we got the notice last week. So we just need to know to tell our owners, because we're getting phone calls daily. So thank y'all.
Right, thank you. I think we need to deal with that today as step one, rather than delaying this particular part of it till Thursday. Does that make sense to the board? Commissioner Lynchard?
One way or the other. I mean, we typically don't take action on Monday. I'd prefer we stick with that. We'll move to Thursday. The number one, directing staff and our county attorney specifically to review the leases on Summerwind and the other residential leases on Navarre Beach, come up with a budgetary impact statement, and also prepare a memorandum regarding the public policy. That would be served by making these leases equitable, making these leases consistent with the other condominiums on Navarre Beach. And then the second part would be to suspend the collection of lease fees until such time as this issue is resolved, or suspend the collection of lease fees till, do we need a date certain? Because we don't want to, I don't know that we need to leave it open-ended, but say.
Well, I mean, I think that you could do it and suspend it through March. That would give us time to
True it up with property tax bills at that point. So suspend the collection of the lease fees through the end of March. 31st. March 31st.
Mr. Chairman. Make that in the form of a motion, Mr. Chairman.
Well, we'll
Excuse me.
move it to
Commissioner Cole.
Thursday.
All right.
Yes.
Just to clarify, would we do that I made a motion earlier, do I need to withdraw my motion? I agree 100%. You want to just piggyback out off the motion I made and move it to Thursday?
That'll be fine. I'll do that. Without, still have a couple of speakers.
Yeah, we have a couple more speakers to go.
Good morning, I'm Catherine Smith, and I am the president of the Summerwind Center Tower. And I just wanted you to know that I'm representing our homeowners, and our homeowners are in duress and very concerned over this double taxation. And I just wanted to ask and thank you for considering waiving the lease fee. Thank you.
Thank you, ma'am. Yes, sir.
Good morning, Robert Coley, 8271 Gulf Boulevard, Navarre. I want to make a point. There was some mentioning of the fact that you were going to be giving up some money by suspending these lease fees at Summerwind. For the last 13 years, you have not been collecting that money anyway, so that's a non-issue. You need to take that into consideration. You're not going to be out any money by giving the lease credit because you've been doing it for 13 years.
Mr. Chairman?
Commissioner Cole.
Just a point of clarification. Robert, I don't mean the lady that spoke just prior to you. Just so everybody knows, we didn't waive the lease fees. We're suspending them. So I don't want everybody to run back and say, hey, we won, we're going to waive the fees. So just point of clarification, Mr. Chairman.
Yes, ma'am.
Andrea McDermott, 8093 Sleepy Bay Boulevard, Navarre. I just had a little question. I was going to say one thing when I stood up, and then you discussed the lease fee and suspending them until March 31st. For clarity, is that for all lease fees or just Summerwind?
Mr. Chairman, my intent was at this time was just for Summerwind.
If I could, Attorney General Opinion 2008-43. It is fundamentally unfair for the legislator to statutorily manipulate assessment standards and criteria in favor of certain taxpayer over others. I would request that you do this for everybody until this can be resolved for the entire beach.
Thank you, ma'am. Yes, name and address, please.
I'm Pam Johnson, 8520 Gulf Boulevard, Navarre Beach. And I think I got up last time and made you all aware that not all of us, even though we don't live in Summer Winds or Beach Colony or whatever, have very high lease fees that we're paying in addition to taxes. So when you took away that credit, I have like I don't know what it is, I think it's like a little bit over $1,600. So without that credit, I'm going back to a $1,600 lease fee plus my taxes, my ad valorem taxes are around almost $2,300. So I caution you guys to please be fair and equitable to all of us, not just Summer Winds, because that taking away of that credit has made a real burden on us that have lived there for, a lot of years. I do own a property on the Gulf side also that was taken away in the hurricanes. So I'm paying both places, and for you to give a suspension to Summer Winds and not give that to the rest of us that are paying fees. Now I know that a lot of them in my area in Buena Vista, their lease fees are reasonable, $500 or less than $500. But the same thing, if you're giving that to Summer Winds at $250, you've got a lot of us, in a lot of different places that we've had other properties totaled, stayed on Navarre Beach, bought an additional, hoping to rebuild and had to stay, that it makes it very inequitable to us if you don't do that for all of us, at least until the issue is resolved.
Mr. Chairman,
thank you.
Commissioner Cole.
Thank you, Mr. Chairman. The question was asked, did I intend that to be for Summer Winds, which truthfully, I don't think it was ever stated, but my intent was, but I don't have any problem whatsoever to extend that to all the leaseholders.
Mr. Chairman.
I don't see any reason that we would, if we're going to suspend the payment for a portion, that we don't suspend it for everybody. It'd probably be easier to administer administratively in that case anyway.
And that would be the residential. That would be the residential leases.
If you touch the right-hand part of that button, it'll turn the red light on.
Yeah.
The light went out again, Dennis. Just touch it and leave it alone. Now there you
I'm
go.
sorry. Okay. My name's Dennis Haas. Good morning. I live at 1110 Santa Rosa Boulevard in Fort Walton Beach, but I own a condominium over here in Navarre. Actually, I own two. Just recently sold one. I'm a little bit confused, to be honest with you, and hopefully maybe others are a little dense sometimes. But I understood some conversation about a 99-year lease versus a 100-year lease. And it's, if I understood this right, and correct me if I didn't, if you had a 100-year lease, there wasn't going to be really then a beach lease. Is that correct?
Well, there is a statute that referred to the 100-year lease and said that if it's 100 years, it's the equivalent of ownership. And that, I think, was the basis for a time period when there was not taxes due. The Florida Supreme Court determined that that was essentially unconstitutional, and that in the case, the fact that it has an original term of 99 years, when the leases on Santa Rosa Island, the leases on Navarre Beach, have an original term of 99 years, an automatic renewal of another 99 years, and that additional 99 years carries the same terms as the original lease, including further renewals. So your lease is perpetual. It's not a 100-year lease. It starts with a 99-year lease, and it goes forever.
If it were a 100-year lease, would that resolve this situation in any way?
No, it wouldn't.
Okay, that was the first question. The second question is, I've listened to some other people talk about mixing in Summer Wind with other property owners, and I guess it's my understanding, again, that this whole issue that we're talking about today is really because of the Summer Wind's lease agreement. Doesn't really affect any of these other people. There was another lawsuit earlier, probably several years ago, but Summer Wind was not a part of that. So I think there's a little confusion maybe perhaps going on what we're discussing at this particular time and what other people are bringing to the table.
I think the commission has voted or indicated that they're going to bring to a vote at the Thursday meeting a suspension of collection of all lease fees until March 31st of next year to determine what, if any, relief can be given.
Yeah. Okay, well, thank you.
Commissioner Williamson?
Thank you, Mr. Chairman. And I just wanted to clarify for public record that whenever I mentioned that the extension and then we came up with the March 31st, I meant for all the residential, not just one group over the other.
Thank you, sir. Yes, ma'am.
Does Escambia County hold full legal title to this land?
The deed was from the United States government to Escambia County with a reverter clause essentially on it. And then there was a master lease of that provision or that portion of the property that is now in Santa Rosa County. And the terms of that master lease, which are incorporated in most of the other leases, is again 99 years originally with an automatic 99-year extension and including further renewals. So Santa Rosa County has equitable ownership of the property. Escambia has bare legal title to the property, subject to a reverter to the United States government.
So Escambia holds legal title as security? Is that how that would read?
No, ma'am.
Santa Rosa County holds title as what? Full title? Or Escambia County owns full title, or the United States government owns full title? Who owns it?
Well, I would say that Escambia County has bare legal title subject to the reverter in favor of the United States government, and Santa Rosa County has a perpetual lease.
Okay, thank you. And I wanted to say I think it's a good idea to extend the suspension of leases to all, not just one entity, because if you just do it for one, you're teetering on discrimination. Thank you.
Thank you. We'll take this last speaker, then the board's going to vote.
I'm sorry, I had one other question and I forgot to bring it up. Pam Johnson, 8520 Gulf Boulevard. At the last meeting, I believe Mr. Coley brought up about the possibility of the county amending the leases so it'd be equitable to everybody if you decided on a certain, rate or number for those leases. Has that been looked into, or?
I think that would be the basis for any action taken by the county, but there has to be a valid public policy served by such an amendment.
Will you all be looking at that at your workshop as a possibility of that?
Yes.
Okay, so we can expect that that leases can be amended, since all of them that I know have been amended on the island.
The county doesn't have unlimited discretion in regard to that. It's a fiduciary for the citizens of the entire Santa Rosa County, but as long as there's a public purpose served thereby, then there can be an amendment.
So are you saying that actually the citizens would have to vote on such a
I'm not saying
addendum or
that.
something?
The county commissioners act on behalf of the citizens, but they have to have a legal basis for doing so.
Okay, and you can't determine whether or not at this point that there would be a legal basis for that to be equitable?
We're kind of looking at that.
Okay, thank you.
All right, thank you very much for your participation in this question. We have a motion on the floor. It is a motion on the floor without objection you want to restate that for the record, or do you have it? Okay, and that's without objection, and hearing none, it passes. The time is 10:25. Let's be back in place at 10:35, please, and we'll please begin to make your way back to your places. Okay, we have a quorum. Commissioner Cole will be with us shortly. Will someone see if he's out in the foyer? All right, we're on the Administrative Committee, and it's item number 2, discussion of interlocal agreement with Emerald Coast Utility Authority, the ECUA, for solid waste and recyclable collection services north of the Yellow River, effective January 1st, 2015. Details are in the backup. Any comments from the commissioners on this? I recommend we move this to Thursday without objection.
Mr. Chairman, I think there are a couple of folks that are here that want to speak to it.
There you go.
Good morning, Mr. Chairman, members of the Commission. My name is Robert Tracy. I live in Morgan Ridge, which is up off of Willard Norris Road in Milton. I'm here as a concerned citizen, and I kind of represent a lot of my neighbors and friends, too. We are all pretty satisfied with the service provided by Waste Pro and even Waste Management. But rather than get into that, I understand from talking to Mr. Lynchard, it was a bid issue, and ECUA came in way below everybody else. So the old saying, if it seems too good to be true, it probably is. So that's one of my concerns. The other is, what sort of language are we going to have to do something if their service is not adequate or not up to the expectations of not only the Commission but the citizens? If they do a lousy job, what are we going to be able to do about it?
I'll let Mr. Andrews handle that one.
Yeah, currently, Mr. Tracy, is that we do have two franchise areas in the southern part of the county. I understand that, yes. That's right. Mm-hmm. In the event that there's some dissatisfaction with either provider, they're notified, we're notified, and then we have a person on staff that will follow up and get those, make sure that they're resolved.
Okay, thank you.
I mean, that's typically how we would do. We have the same contract or the same mechanism set up here, because the whole point is to get the best service we can for the residents. And
I understand, sir. Thank you. Thank you, gentlemen.
And I'll say, Mr. Chairman, in the south end of the county, some 3.5 years ago, when we went to this, there's a little transition period there when your existing providers are picking up cans and the new providers coming in and trying to deliver cans and get their routes established. So, there will be a few weeks there where it's going to get better. But after that service is established, in the south end of the county, we have very few issues. And normally when there are issues, again, we have someone on staff who is our liaison with the waste haulers, and problems are resolved as quickly as possible. We'll make sure that the same thing happens up here.
One little question that also popped up: why are we doing this? What's the basic reason?
Well, there are a number of reasons. One, cost. I know in our case, we were paying $70 a quarter for twice a week garbage pickup. That's it. Now we pay $52 a quarter. We get twice a week garbage pickup. We get recycling pickup in the same size bins once a week, yard debris every other week, and bulk item as needed. So if you have a refrigerator or a couch you need to get rid of, you take it out by the side of the road, and your waste hauler picks it up and takes it off. No additional charge.
Wow.
So all of that's included. In addition, I live in a small subdivision. You used to live in Tiger Point. You mentioned I live in Tiger Point. We had between 5 and 7 different haulers operating in my subdivision. So you had heavy truck traffic 5 days a week, and these are the heaviest trucks on the road. You know, garbage trucks are 60 to 70,000 pounds or more when they're full. So we cut that down. We have 2 of those trucks come through a week to pick up garbage and once a week to pick up recycling. So it has cut the truck traffic down to a fraction of what it was before.
Understood,
So that's less wear and tear on our roads.
Very good.
Just better overall.
One little comment, gentlemen, which has nothing to do with this issue. After listening to all the numbers for people that live on Navarre Beach, I'm glad I live in Milton. Thank you. Thank you very much.
Anybody from the audience have anything else to add to this? I recommend we move to Thursday without objection. Hearing none, it passes. Item number 3 is discussion of scheduling interviews with 8 firms submitting proposals for the lobbying/advocacy services with the state of Florida. Details are in the backup. I recommend we move this to Thursday without objection. Yes, sir,
Mr. Chairman, if we could, we had 8 firms. I would ask if we can direct staff to shortlist that down to about 4 to bring to us on Thursday, and then we'll set up interviews for December with the 4 that they choose. If that's good
Do you
with
do
everybody
that
else.
without objection?
Without objection.
Anybody, comments? Hearing Commissioner Williamson?
Commissioner Leonard or staff, I mean, how would we decide to go from the 4 to the or from the 8 to the 4? What, I mean,
Based on qualifications and quality of the package that they submitted, and then I'll give my input to Mr. Walker, and each of you can do the same.
I'd like to give my input as well to Mr. Walker.
And if we can't come to 4, you know, we can interview all 8. I'm just, as a matter of expediency, typically, you know, 4 will stand out, 5, something like that. We'll be able to cut it down somewhat.
All right. The staff understands the will of the board there, so I recommend we move this to Thursday without objection. Hearing none, it passes. Item number 4 is discussion of cancellation, termination of real property purchase agreement with Milton Crossings LLC based on local option sales tax referendum. Recommend we move this to Thursday without objection. Hearing none, it passes. Item number 5 is discussion of the following proposals from Pegasus Engineering LLC for preparation of hazard mitigation grant program HMGP grant applications for April flooding allocations, and then we have 4 breakouts. Ranchettes, North Ridge and Whisper Bay subdivision drainage improvements at $44,750, Tier 1. Villa Van East subdivision drainage at $25,830, also Tier 1. Patterson Lane, Pace Lane drainage at $24,985, which is Tier 2. And Maranatha Way, Chipper Lane drainage at $24,985, also Tier 2. I recommend we move these to Thursday without objection. Hearing none, it passes. Item number 6 is discussion of an agreement with the West Florida Regional Planning Council for annual small quantity hazardous waste generator assessment and notification program. Details are in the backup. I recommend we move this to Thursday without objection. Hearing none, it passes. Item number 7 is discussion of an interlocal agreement with West Florida Regional Planning Council for subsequent technical assistance task orders. And again, the details are in the book. I recommend we move this to Thursday without objection.
Mr. Chairman?
Yes, sir, Commissioner Cole.
Just a question to County Administrator. Is there any cost for their administration on this, or is that all included in what they're already doing?
Yeah, there's obviously no cost in this master agreement because there's really not any action for them to take. Is that what we would do would be to bring back to the board subsequent tax task orders. For example, you could tie in your small quantity generator contract or task order every year. The board would have to do that. They have to do all of them. If you remember, we recently did the bike and pedestrian path study with the West Florida. And when I ran into Ms. Joseph at the symposium, that was what she had recommended. Said, I believe they've got 2 other counties that they have that arrangement with. And it seemed reasonable to me.
I recommend we move item 7 to Thursday without objection. Hearing none, it passes. Item number 8 is discussion of the contract with Motorola Solutions Incorporated for public safety radio system upgrade to P25 standards digital radio / communication system in the amount of $7,279,240 based on governmental contracting pricing and authorized execution of the relevant documents. Details are in the backup. I recommend we move this to Thursday without objection. Commissioner Cole.
Mr. Chairman, when this was last on the agenda, and I certainly agree we need to implement this program, but we were going to continue investigating ways of paying for this, and I just didn't know if we'd come up with any other solutions on the payments.
If this is at least the way that the current project is structured, is that it will require over the next, I believe it's 12 months, we've reserved the $2 million, if you'll recall, for the essentially the down payment on that, and then we will come back to the board with options for the payments for the 7 years, and we'll bring that back. But we needed to go ahead as had been briefed in, I believe it was July, August, and then October, that we needed to proceed with getting the contract established with Motorola. Also, you'll see the next action would be the agreement with Escambia County, and then we've still got to proceed with the school board and a site for the Munson area communication tower. So this just starts us down the road. But yes, we'll have to bring back those alternatives too.
I recommend we move item number 8 to Thursday without objection.
Mr. Chairman?
Yes, sir.
On an unrelated item, but it does involve communication. I'm getting some email traffic that says we don't have an option right now to watch on our website to watch this meeting. So if we could have somebody look into that. Thank you.
Okay, is there somebody in the communication room that maybe heard that? All right, we're not streaming live. If you could please take a look at that. Item number 8 did get moved to Thursday without objection. Item number 9 is discussion of interlocal agreement with the Escambia County Board of Commissioners for shared use of P25 public system and authorized execution of the relevant documents. Details are in the backup. Recommend we move this to Thursday without objection. Hearing none, it passes. Item number 10 is discussion of proposed joint U.S. Environmental Protection Agency, EPA, and U.S. Army Corps of Engineers definition of waters of the United States and the impact on the counties, and this is a Monday action. Mr. Walker.
Mr. Chairman, in your packet, this is, and Commissioner Cole may want to speak to it, this is a matter that he's been pursuing through the National Association of Counties, NACO, and in your backup is a proposed letter of concern or regarding this, it's not actually legislation, it's actually rulemaking that's undertaken by EPA and the Corps of Engineers. And while the impacts on Florida are fairly negligible, quite frankly, because most of these requirements we already have through the Water Management District and some of the other items, it still is a reach on definition and that type of thing. And I believe that Representative Miller has, if I read the background information, that he had dropped a bill more concerned with not only the impacts in Florida, but just the overreach of rulemaking.
The overreach of rulemaking in this particular agency in general, I think, is a concern to most everybody that's a right-thinking individual that loves smaller, less intrusive government.
And the reason for the Monday action today, I believe, and Mr. Cole may speak to it, I believe the Thursday or Friday is the deadline for the comments.
Commissioner Cole.
Thank you, Mr. Chairman. Yeah, this came to my attention through NACO, and I did talk to Congressman Miller. He did co-sign with Congressman Sutherland bill to curtail this, but I'd like to show our support. There's also, I think, a total of 6 governors and 6 state attorney generals that have also voiced in on this. So, again, just keeping federal government out of our business and shortening the process. There is some speculation and some conversation that, you know, something as simple as Public Works wanting to clean out a ditch would require a Army Corps of Engineer permit to do it. And we all know how quick they are to respond on their permitting process. So I'd like to get that because the 14th is the deadline for comments.
I recommend that we
Mr. Chairman?
approve this action. What?
Mr. Chairman, I would just like to edit the letter to include an absolute regulatory exclusion for stormwater management systems in the letter specifically.
Okay.
And then that'll clear that up. Currently, we do have to do a nationwide 3 permit to wipe out jurisdictional ditches and those swells, but with the new rule, they would have the ability to go all the way up into the retention ponds that are clearly in uplands who are created to treat stormwater and become jurisdictional. So if we get that exclusion, I think that would be very good.
I recommend approval of the joint use letter as amended and edited by the county engineer. Do so without objection. Hearing none, it passes. Item number 11 is discussion of scheduling public hearings on amendment of ordinance 2005-37, suspending transportation impact fees for 2015. Mr. Walker.
Yes, Mr. Chairman, is for the last number of years, I believe since 2008, I believe, is the board has suspended the collection of transportation impact fees for specific calendar years. In the event that the board wanted to continue that suspension, this would be the action. We'll have the public hearing at your December meeting, which would be effective for calendar 2015.
Comments from the board? Commissioner Leach.
Thank you, Mr. Chairman. We've suspended this for, this will be our 7th year, I guess, 6th or 7th time that we've suspended in a row. I think it may be time to take a look at the impact fee ordinance and then either do away with it altogether and say we do not want to have impact fees in Santa Rosa County, or reimpose our impact fee or some modified version of it. You know, we have all heard over the past 6 months the call for new development to pay for itself when it comes to stormwater protection and roads. So that's what your impact fee is for, but philosophically, I think we need to either reimpose the impact fee or do away with it and quit going through this thing of every year, let's suspend our impact fees. Let's settle it once and for all. My thoughts on it.
Do you want to do that? Are you adding that to today's discussion for determination on Thursday?
We need to have a public hearing on that, or a couple, I would think, on, you know, it's one of the things that would be better served at a workshop.
Okay.
The impact fee.
Why don't we go ahead and move this to Thursday and schedule a workshop for final determination? In other words, go ahead and deal with this year, just like we have in the past, and set up a workshop and begin to implement your idea, because I think it's an excellent suggestion. Comments from the board?
Would we not, we'd have to schedule the public hearing before we did any kind of action on this item, wouldn't that be correct?
Yes.
It would anticipate.
To include the suspension that we're discussing now?
We have to have a public hearing in order to suspend them.
On that, so let's just make that all one piece then, when we schedule the public hearing to contain.
Actually, I
that.
assume because obviously your public hearing will be on whatever ordinance you advertise at your December meeting. If you're thinking about Mr. Salter's projected planning workshop, that'll be in January. So we would need some kind of resolution for the coming year, and it does seem reasonable. We go ahead and schedule this, and then whatever long-term action that you take, you can take when you're ready, if that makes any sense. And also, let's also remember this is transportation impact fees. It's not the water and sewer fees that the utilities charge. We always kind of get, because of our permitting situation, we always kind of get painted with that brush, but it really only is, the only thing you have discretion over is your transportation impact fees we've not collected for the last number of years.
Can the staff bring us a schedule Thursday?
Surely.
For a public hearing?
Surely.
Any further input from the board?
Mr. Chairman?
Yes, sir.
Just clarification, so our intent at this point would be to suspend them for one more year, but have a thorough discussion whether after that year we would re-implement them or discontinue them.
But all of that requires a public
I understand
hearing,
that. I
so
just
that's
didn't want to know
what-
if we were going to suspend them for 3 or 4 months, and then
Mr.
I'd
Chairman?
like to just know what the intent is.
I don't think we're suspending or continuing anything today. I think we're just going to approve having a public hearing so we can make that decision.
Commissioner Cole? You have
Well,
another
what I
comment?
heard, though, that was the public hearing would indicate we were going to do it in January along with the workshop. Am I correct?
The
I
public
think it would
hearing
be
would be
December,
on.
correct?
The public
At the
hearing-
December meeting, would the public hearing be at our December board meeting? Is that correct?
It would be on what we'd anticipated. It will be on whatever ordinance that you would consider for public hearing. Your ordinance requires a public hearing and then passage. The proposed ordinance that we have in your backup is the suspension of the transportation impact fee for calendar 2015.
Well, Mr. Chairman,
So
I just don't feel like between now and December, with all the time it took to implement that impact fee, with the study from the lawyers with the rational nexus and everything that went into that, and the demand we've seen at that time from the citizens to have construction and growth pay for itself, that between now and December would give ample time to inform the public that we're going to have this. My suggestion would be that we suspend it for one more year, allowing this next coming year to take our time and really review this, rather than try to do it.
And that's what I anticipated for the December meeting. And the only action we could take at that public hearing in December would either be to, the only action we could take affirmatively would be to extend the suspension for another year. If we take no action, then the impact fee that's on the books would apply for 2015. Now, we could modify that after our January meeting if we choose.
Mr.
Okay.
Chairman?
Yes, sir.
And just to piggyback off that lane, or Commissioner Lyncher, basically, if we do go to suspend it again for another year, then we really need to take a hard look in January about it if we just get rid of them, because that would be 7 years in a row that we're suspended, and it would just be one less thing that we're having to do. Let's commit to just taking them off the books if that's the way the board goes.
That's right. If we're going to do it every year, why have it in place? Let's make that determination. Do we want to have impact fees on new construction and have them contribute to stormwater maintenance, road maintenance, et cetera, or not?
Well, this particular one is transportation, but yeah, we'll need to look at the whole ball of wax. Would you form us a motion here? We've kind of moved around a lot of
I think we're
territory.
good. We take this existing
verbiage
to Thursday, because the
Okay.
action we take in December won't change. Really, what I was
All right.
bringing up was, let's think long and hard about it at our December meeting.
Okay.
Because it's a big decision as we move forward. I mean, if you look back at what the impact fees have paid for over the past several years, the 5 Points project, things down in the south end of the county, among them what we're going to be talking about in just a moment. So I think we need to make that determination whether to continue them or just do away with them altogether.
Okay. All right, I recommend we move this to Thursday. You've got to be careful here. You better speak with Roy about whether or not you can speak to something you have to vote on later. I'm not so sure that's kosher.
Just a general question.
Okay.
Rob Williamson, 7018 Summit Drive. What's the deadline on the decision or the matter that y'all are discussing? When do you have to know on what is going to be the will of the board related to this ordinance?
The end of the year, if we're going to suspend the imposition.
December 31st?
Yeah.
That's why this public hearing would be sometime in December.
Thank you, Mr. Chairman.
Okay. Okay, I recommend we move this to Thursday without objection. Hearing none, it passes. All right, item number 12 is discussion of completion of a multi-use path on East Bay Boulevard using Area 3 transportation impact fee revenue. Details are in the backup discussion.
Mr. Chairman, just if I could point out, this will, in essence, complete the loop, the multipurpose path on 399. This is a big segment. It's approximately 3.5 miles that Mr. Whitfield has come up with the estimate on.
Okay.
So this would complete that loop with the exception of the possible bridge there at some point in the future.
Well, I think the bridges would be just, we've already kind of decided that's going to have to wait. Going to have to wait for somebody.
But this will complete the loop for all of those people who travel that path on 399.
I recommend we move this to Thursday without objection.
You know, one of the things that we may need to consider is especially, we need just to look at, we've got the estimate of the public works estimate that's about $986,000. Also, then we've got a couple of the other projects that have been scheduled in that. I want to be sure that we've got the appropriate amount of funds to do all the projects. So we just need to come back and look at that.
All right, I recommend we move this to Thursday without objection. Hearing none, it passes. Item number 13 is discussion of employment services agreement with Stephen Furman for the position of Public Works Director effective July 1, 2015. Details are in the backup. Unless there's discussion from the commissioners, I recommend we move this to Thursday without objection.
Mr. Chairman?
Commissioner Cole?
Yeah, thank you. I know this is a recommendation. I was just wondering why this would come through the board and not be a decision made totally by the county administrator.
Again, you guys, the board approves all the employment contracts. I mean, that's essentially what this is. And as I outlined in my memorandum, is Mr. Whitfield has started his long glide to retirement. And that if I'm any judge, that slope will get steeper and steeper as time goes through. So we do need to go ahead and I made the decision or make the recommendation that we would proceed with Mr. Furman, and based on all the reasons that I had in my memo, and based on a very solid recommendation from Mr. Whitfield, so we need to go ahead and get that position, start advertising the assistant position. Mr. Whitfield clearly will be the Public Works Director until his retirement of June 30th. This would be effective July 1. Was just to go ahead and get that decision done so that we would actually double fill the assistant position for that period of time, again, just because of the transition issues in a very important department. I mean, Mr. Whitfield will be here 38 years. I mean, just his institutional knowledge, and then Mr. Furman's, we're going to have to get somebody up to speed to start with those discussions.
I recommend we move this to Thursday without objection. Hearing none, it passes. Item number 14 is discussion of amendment to Florida Department of Environmental Protection Agreement for the time extension for the Recreational Trails Program grant for Baghdad Mill Site. Recommend we move this to Thursday without objection. Hearing none, it passes. Item 15 is discussion of appointment of commissioner or designee to the Tri-County Community Council Incorporated Board of Directors. Any comments from the board?
Mr.
Commissioner
Chairman?
Salter? Yes, sir.
I would recommend Mr. Walker for Thursday's agenda without objection.
Okay. Hearing none, passes. Take that up Thursday. Item number 16 is discussion of proposed equipment replacement vehicles and related capital purchases for 2014, 2015. Mr. Walker.
Mr. Chairman, in your packet is kind of our tentative list of the capital purchases, which really primarily is the replacement of equipment, vehicles, and equipment. There's some maintenance items in there, including carpeting for the auditorium and this office that we'll have some discretion on. Also, a facade on the economic development building out to the out parcel here that we're having some rain intrusion. So this is just a list that we'll start down. Once we get approval for this, then we'll start bidding these items in accordance with your.
As a matter of public interest, it would be nice to publish at the same time or approximate time a list of things that we're declaring surplus that are no longer useful in our hands.
I think that they have. I believe that the clerk, and because Mr. Spencer can speak to that, I believe they're the
custodian.
I'm sorry. Yeah? We can do that. I mean, since the board only does that once a year, we could do that.
Okay. Okay. That'd be nice to kind of do that as a package, Commissioner Cole. Yes, Commissioner Cole.
Thank you. And one other thing, $45,000 to carpet the auditorium. Do we want to consider maybe putting tile or something in there since there's a high traffic area, or any particular reason we want to go back with carpet?
No particular reason. I'd be happy to get Mr. Whitfield and Mr. Allen and kind of look at that. It may be for no other reason than it's always been thus.
Well, yeah, that's not always a good reason. Okay. Any other discussion from the board? I recommend we move item 16 to Thursday without objection. Hearing none, passes. Item 17 is discussion of the third annual Kite Festival on January 17, 2015 at Navarre Beach Park. Details in our backup. I recommend we move this to Thursday without objection. Hearing none, passes. Item number 18 is discussion of the annual renewal of a permit to provide advanced life support, ALS, non-transport emergency response services to the Midway Volunteer Fire Department. Details in the backup. I recommend we move this to Thursday without objection. Hearing none, it passes. Item number 19 is discussion of the annual renewal of the permit to provide advanced life support, ALS, non-transport emergency response services to the Pace Volunteer Fire Department, and I recommend we move this to Thursday without objection. Hearing none, it passes. Item 20 is information only. Public hearing item scheduled for 9:30 Thursday, November the 13th, which will be in Gulf Breeze, will be the vacation of the unnamed right-of-way between lots 1 through 6 and lots 7 and lot 10, block 641 of the Avalon Beach Subdivision, Plat Book A, page 1-10. I recommend we move this to Thursday without objection. Hearing none, it passes. Item number 21 is an informational item, and I believe that was from Commissioner Litcher.
Thank you, Mr. Chairman. Just a couple of things. First, last week, had the opportunity to attend FWC meeting at the Tiger Point Community Center on land use and access management planning for Escribano Point. Escribano Point's about 3,000 acres under control of FWC. We always called it Scavan Point when I was growing up. So, but Escribano Point, went out there with Rick Harris last Monday. It is a just absolutely magnificent area. The oak trees and just undisturbed forest around there is really, really something special. But the FWC presentation dealt with their short intermediate and long-term plans and goals for the development of Escribano Point, maintaining that public access, increasing opportunities for public access to Escribano Point. They went over some of the immense diversity of the wildlife and plant life that's out there. There are about 17 historical and archaeological sites out there that they've identified, and really they've only studied the first 1,000 acres that they had, so they still have 2/3 of it left to review in depth. So it's really something else, though. Grassy Point, the campground area out there, very nice. They're going to make some improvements there. So if you have an opportunity to go out and visit Escribano Point, I encourage you to do so. You can also go to the FWC website, look on the Escribano Point management area plan, and you can see copies of that land access management plan. And they're going to be still soliciting input on that from the public as we move forward. Second, just a reminder to the board, the Restore Council will be 2 years old in December. So our appointees were, they served 2-year terms. So I don't know if there are any of the appointees on the board who want to come off, or if any of the commissioners want to make a change. I think everybody's been extremely engaged. It's not something that you can just step into and you're up to speed on. But we will need to make those appointments or reappointments at the December meeting. Also need to get staff to reach out to the other appointing agencies, the municipalities and the Navarre Chamber, to get them to reaffirm their appointees for their positions. But you know, the last 2 years for the local Restore Council has been largely about developing the process, waiting on the regulations to be issued. Now the regulations are final, and we're moving into the next phase for the Restore Council. So our application is going to be finalized shortly, and starting around the first of the year, we'll actually start soliciting projects and then begin the vetting process, so that by mid-year of 2015, we should have our multi-year implementation plan, or at least a good draft of it in place. That's right. Yeah, just to remind everybody, Restore, the BP money is still unresolved. You know, the litigation's still ongoing over in New Orleans, but Transocean settled already, and Santa Rosa County's direct allocation from Transocean will be about $4.4 million. And that will all be available. I think March is their deadline for making that last installment into the Restore Trust Fund. So about $3 million, 3.2 is already there. The final installment will be available in March. So we are not just developing a plan for when BP settles, we're developing a plan for money that's already in the works.
And just to follow up is that the Treasury Department has finalized its guidelines. We've been involved with them through training and our staff and our consultants, and they've told us that they're going to primarily treat this Transocean money for everybody, but especially the direct, disproportionately impacted communities in Florida and then each of the individual states. This is going to kind of be their test run as they get ready for the Restore money. So this will be a good ramp up to do that. But we'll have it on the agenda for your appointees
Okay. All right. Anything else to add? I believe that will complete the administrative committee report and bring us up to the engineer's report. Mr. Blaylock.
Thank you, Mr. Chairman. Members of the board, item number 1 is the discussion of our annual topographic survey and capacity calculations for Central Landfill. Part of our permit requires that we maintain this calculation and submit it as part of our permit each year. And as you know, our landfill, we collect by tonnage, but we sell it by airspace, if you will. And so we have to have detailed information on what that airspace is for DEP, and we do that in the form of an aerial flyover We're utilizing the SCS engineers who we used in the past. They maintain the database and can make that calculation very quickly for us.
Okay, I recommend we move this to Thursday without objection.
Okay. Items number 2, 3, and 4 are those road damages from the April 29-30 flooding within Santa Rosa County. Item number 2, we're discussing the change order number 1, and this is change order number 1 and final to the contract with Panhandle Paint and Engraving in the amount of $66,358.15 and 22 additional days. The additions are those areas that we discovered after the bids were awarded and in conjunction with FEMA, the state, and Public Works and Engineering personnel.
I recommend we move these to Thursday without objection. I'm talking about items 2, 3, and 4 now.
Yes, sir.
Hearing none, it passes.
Item number 5, we have a discussion of the rail easement and supplemental agreement with the Gulf Cable project. As the board may recall, this is an EDTF grant supplying a rail spur from the existing county rail spur into our industrial park for Gulf Cable. As we went in through the project, it was realized that part of that rail was going to be on their property, and the state was not going to participate without this easement. Gulf Cable has agreed to the easement, and that's what we're doing here today.
Okay. I recommend we move this to Thursday without objection. Hearing none, it passes.
Item number 6 is a preliminary plat that's a candidate for Thursday's meeting. It's Cambria subdivision, a 170-lot subdivision in Working District 1.
Okay. I recommend we move this to Thursday without objection. Hearing none, it passes.
Item number 7 is a final plat approval for Pace Mill Creek Phase 3A. This is a 70-lot subdivision of a portion of Section 33, located also in Working District 1.
I recommend we move this to Thursday without objection. Hearing none, it passes.
Item number 8, we're recommending the approval of the paved road and drainage maintenance for New Haven Estates. This is a 23-lot subdivision that's been completed, the punch list completed, and Road and Bridge and Engineering concur with this recommendation. It is located in Working District 4.
Okay. I recommend we move this to Thursday without objection. Hearing none, it passes.
And finally, we're recommending approval of the paved road and drainage maintenance for Promise Creek, a 117-lot subdivision located also in Working, or I should say, in District 4. There's no longer any working districts. I stand corrected. And we have the concurrence of Public Works and Engineering staff.
I recommend we move this to Thursday without objection. Hearing none, it passes.
And that concludes the engineer's report.
Okay. Public Services Committee, Commissioner Richard.
Thank you, Mr. Chairman. Item number 1 is discussion of the SHIP mortgage subordination request for the property located at 5251 Tracy Drive in Milton. This request is consistent with board policy. Unless there are any questions, I'll move this to Thursday without objection.
Hearing none, it passes.
Item 2, discussion of the SHIP mortgage subordination request for the property located at 5476 Camille Gardens Circle in Milton. This request is consistent with board policy. Move this to Thursday without objection.
Hearing none, it passes.
Item 3, discussion of the SHIP mortgage subordination request for the property located at 3848 Hazel Godwin Road in J. This request is consistent with board policy. I'll move this to Thursday without objection.
Hearing none, it passes.
Item 4, discussion of the following 13 public locations for placement of the signage for the FEMA High Water Mark Initiative: Shoreline Park Boat Launch, Navarre Visitor Center, Riverwalk on Blackwater River, north side of Avalon Bridge, Bay Bridge Boat Launch, west side of Gulf Breeze Parkway, Oriole Beach Boat Ramp, Navarre Beach Park, Carpenters Park Boat Launch, Andrew Jackson Drive Boat Launch, Russell Harbor Landing Park, Deaton Bridge, Woodlawn Beach Boat Ramp, and the south side of the Avalon Bridge. Also, the kickoff event will be held at the Navarre Visitor Center located at 8543 Navarre Parkway, Navarre, Florida, on December 9th, 2014, beginning at 11 a.m. Unless there are any questions, I'll move this to Thursday without objection.
Commissioner Cole.
Thank you, Mr. Chairman. Who's administering this program? Are we, or?
This came through our grants department. This is a FEMA program, and came through, I think, did it come through the LMS committee, Mr. Gomillion?
Yes, our flood management office would be administering it. and through, in cooperation with the LMS committee and members, municipalities. It's an awareness program, and so.
Okay, if we could, I'd like to include the Bay Area Resource Council through West Florida Regional Planning.
Sure. Well, we will certainly invite that group for the kickoff event.
Thank you.
I cannot recall the name of the little fish camp on 90 across the field right in there. Isn't there one in Santa Rosa County right there, or is it washed away now?
There is, we have focused in, and the whole project has focused in on public boat launches and public areas because of the nature of it. It's a high water mark initiative, so they're going to put signs out that show where the high water mark is. So we didn't want to, you don't want to put those on private property. You know.
Okay, yeah. All right,
Mr. Chairman,
go ahead.
I thought the county had a boat launch over on the field, don't we?
We've got the area where you can fish from. That would be one of the parks in District 1.
Okay.
Well, if there is, we can back up and catch it. I just was curious.
Yeah. Okay.
Recommend this to Thursday, sir?
Yes, without objection.
All right, sir. Hearing none, it passes. That winds up public service. Next is Public Works Committee. Commissioner Williamson.
Thank you, Mr. Chairman. We have 5 agenda items today for Public Works Committee. Item number 1, discussion of resurfacing the following roads in District 5 at an estimated cost of $85,179. West Avenue, Oakwood Lane, Sea Line Court, Sea Line Cove, Elliott Lane, Sandy Bluff Drive West, El Prado Street, Baghdad Cove, Point Shores Lane, Medora 4, and Medora 5. I'd like to move to Thursday without objection.
Hearing none, it passes.
Item number 2, discussion of paving Republic Court in District 5 at an estimated cost of $5,690. I'd like to move to Thursday without objection.
Hearing none, it passes.
Item number 3, a discussion of change order number 2 in the amount of $2,140 with Pneumatic Concrete Company, Inc. for an additional 4 linear feet of structural pile jacket at the contract unit price on the Munson Highway Bridge Rehabilitation Project, with 75% of the cost being reimbursable through the FDOT SCOP grant for this project. Mr. Whitfield, would you like to add something to that?
No, sir. I mean, it's just, we pointed out that it's 75% reimbursable, and it's a relatively small change order amount. It's just at unit pricing, so it's just real straightforward.
I'd like to move to Thursdays without objection.
Hearing none, it passes.
Item number 4, we have discussion of proposals for drainage pipe repairs in Woodline Heights subdivision and Santander subdivision. Mr. Whitfield, do you have anything you'd like to add to that?
Yes, sir. We put this on the agenda as a placeholder because we're still in the process of obtaining proposals, comparison shopping proposals. We do have 2 of the 3 that we've asked for, and we expect to get the 3rd proposal in today or tomorrow, so we can provide that information to the board prior to Thursday's meeting. It's 4 separate locations where we need to do storm drain repairs in 2 different subdivisions. The reason we're not doing these in-house is because it's there's some equipment that we don't really have as far as dewatering. It's also working in very close quarters between homes. We would like to contract these. The relatively small projects, we feel like all 4 projects combined will be less than $30,000. So we'll bring you our recommendation on whatever the low proposal is by Thursday, and hopefully be able to, even before that, provide that information to you.
Thank you, Mr. Whitfield. If we don't have any questions from the board, I'd like to move to Thursday without objection.
Hearing none, it passes.
Item number 5, discussion of resurfacing the following roads in District 1 at an estimated cost of $159,338. Pecanwood Place, Praline Lane, Andrea Lane, Pace Lane to Mundy Lane, Highland Boulevard, Sherrill Court, Gatewood Lane, Vern Cove, Tillwood Drive, Jabro Drive, Gerlum Drive, Teakwood Drive, and I'd like to move to Thursday without objection.
Hearing none, it passes.
Mr. Chairman, that concludes the Public Works Committee.
Okay, Budget and Finance, Commissioner Cole.
Thank you. Item number 1 is discussion of bids received for the housing rehabilitation project located at 4470 School Street in Baghdad. Low bidder meeting specification is Kaiser Siding and Construction, Inc., with a bid of $14,775. You can move that to Thursday without objection.
Hearing none, passes.
Excuse me. Item number 2 is discussion of Budget Amendment 2014-178 in the amount of $270,752 to recognize the $2 recording fee revenue and distributes to Escambia County for expenditures in the Fine and Forfeiture Fund. Move that to Thursday without objection.
Hearing none, passes.
Item 3 is discussion of Budget Amendment 2015-050 in the amount of $41,384 to adjust debt service to amortize schedules in the Debt Service Fund. Move that to Thursday without objection.
Hearing none, passes.
Item 4 is discussion of Budget Amendment 2015-051 in the amount of $257,330 to carry forward unspent BP monies and allocate for expenditure in the Tourist Development Fund. Move that to Thursday without objection.
Hearing none, passes.
Item 5 is discussion of Budget Amendment 2015-052 in the amount of $124,969 to carry forward the E911 fund balances for previously authorized but uncompleted purchase of the Entrado or Positron Viper system upgrade in the E91 program fund. I move that to Thursday without objection.
Hearing none, it passes.
Item 6 is discussion of Budget Amendment 2015-053 in the amount of $81,973 to carry forward funds for updated aerial photographs by Pictometric Corp. For the property appraiser in the general fund. Move that to Thursday without objection.
Hearing none, it passes.
Item 7 is discussion of Budget Amendment 2015-054 in the amount of $964 to carry forward unspent funds for the Jay Public Library from a $2,000 donation from the Curtis Finley Foundation Incorporated in the general fund, and I do so. Move it to Thursday without objection.
Hearing none, it passes.
Item 8 is discussion of Budget Amendment 2015-055 in the amount of $21,425 to carry forward prior year authorized unspent FEMA HMPG grant revenue and require match for Phase 1 design services for Settlers Colony in the Road and Bridge Fund. Move that to Thursday without objection.
Hearing none, it passes.
Item 9 is discussion of Budget Amendment 2015-056 in the amount of $17,880 to reimburse the electric franchise fee fund from the Road and Bridge Fund for HMGP, pre-award expenditures incurred in the fiscal year 2013 for Settlers Colony, and I move that to Thursday without objection.
Hearing none, it passes.
Item 10 is discussion of Budget Amendment 2015-057 in the amount of $2,744,742 to carry forward impact fee fund balance and distribute $229,876 into multipurpose paths, $344,193 into Area 1 reserves, $201,085 into Area 2 reserves, and $1,965,989 into Area 3 reserves, and $3,599 into admin reserves. I move that to Thursday without objection.
Hearing none, it passes.
Item 11, discussion of Budget Amendment 2015-058 in the amount of $90,544 to carry forward prior year unauthorized unspent FEMA HMGP grant revenue and require match for Phase 2 design and construction services for the Ramblewood in Road and Bridge Fund. I move that to Thursday without objection.
Hearing none, it passes.
Item 12 is discussion of Budget Amendment 2015-059 in the amount of $12,945 to carry forward unspent funds in the general fund for the repair of safety netting and 150 feet of additional safety netting along the south side of the multipurpose fields at Tiger Point Park. I'll move that to Thursday's objection with one question prior to moving it. Why would this be out of general funds instead of District 5 rec funds?
It's already been taken out of District 5 and put into the general fund last year.
Okay, just clarification. Didn't want Lyncher getting away with nothing there. All right. Item number
Here, none, it passes.
Item 13, discussion of budget amendment 2015-060 in the amount of $750 to carry forward prior year, fiscal year 2014 unspent grant funds and allocate for expenditure in the grant fund. I move that to Thursday without objection.
Hearing none, it passes.
Item 14, discussion of budget amendment 2015-061 in the amount of $30,155 to carry forward funds in the Road and Bridge Fund for the installation of 160 feet of linear feet of 18-inch liner in the storm drain on Circle Drive as approved at the October 23rd, 2014 Board of County Commissioner regular meeting. I move that to Thursday without objection.
Hearing none, it passes.
Item 15, discussion of budget amendment 2015-062 in the amount of $280,000 to carry forward unspent LWCF grant funds and an additional TDC reserves as approved by the TDC at their June 23rd, 2014 meeting. Move that without objection to Thursday.
Hearing none, it passes.
Item 16, discussion of budget amendment 2015-063 in the amount of $303,540 to carry forward TDC commitments for construction of the Baghdad Mill site and authorizes expenditures for Phase 1 construction items. I move that to Thursday's agenda without objection.
Hearing none, it passes.
Item number 17, the discussion of budget amendment 2015-064 in the amount of $66,920 to carry forward authorized but unspent 2012-2013 Recreational Trails Program grant and match from the TDC North End Reserves and authorized for expenditure of trail construction and purchase of trail side facilities within the Baghdad Mill Site Park. Move that to Thursday without objection.
Hearing none, it passes.
And item 18 is discussion of county expenditures and check register that I'll sign off for your approval on Thursday, so I'll move that to then without objection.
Hearing none, it passes.
That completes this report.
Thank you, sir. Public forum. Please, sir.
Sam Mullins, 5922 Allentown Road. I'm here today to ask the commissioners if they could to please consider reevaluation of Allentown Road. With the current agricultural activity out there, between the peanut trucks going back and forth from the processing plant right up the road and the cotton harvesting that's going on with the combines and everything, we're starting to see large sections of road with multiple radiating cracks in the asphalt. This is the same road that I brought to the attention of the commissioners several months ago and was told that it was on the priority list, but that it was going to be a year and a half to 2 years before we could get to it. We know that we've got a hard winter coming on again. And if we get another hard freeze like we did before with ice on the roads, the road will dramatically deteriorate further. And it is a safety issue because this is the main road for the school buses going to Allentown Road. So, again, I would like to see if y'all could reevaluate that because the road is starting to deteriorate rapidly. Thank you.
Thank you, sir. Commissioner Salter, do you have a comment?
Mr. Chairman, I know when Sam first brought this to our attention, I had asked Mr. Whitfield to evaluate it for us, and it is on the list to be resurfaced at some point in time, but it's going to be a very expensive project. Mr. Whitfield, comment?
Well, I guess it's just a good time to point out again that, we are no longer eligible for the SCOP program, and that's the funding that we used, the grant funding from FDOT, where we got reimbursed 75%. And because our population now exceeds 150,000 in Santa Rosa County, we're no longer eligible for that grant. And so it's probably something when that January workshop takes place where we're discussing a lot of different things that, how we're going to resurface these major roads that cost hundreds of thousands, even millions of dollars, how we're going to find the funding to do that, because we just don't have the funding mechanism that we've enjoyed for many, many years.
And here again, we'll do what we have money to do, and that was one of the things I also wanted to talk about at our workshop, because we've got some big projects looking at us, and we're going to have to find ways to fund them. Thank you.
Mr. Chairman. Commissioner Cole.
I suggest that be a test question for Mr. Furman.
True. Yes, ma'am.
Wallace Mahout, 5500 Cox Road, Milton, Florida. I was just wondering, since the sales tax did not pass to fund the courthouse, what are your future plans to secure a courthouse for Santa Rosa County?
Mr. Chairman, here again, come January, we're going to talk about a bunch of stuff. I think it'd be premature until we start putting together that workshop.
Thank you.
Anybody else with anything to bring before the board? Seeing none, hearing none, we are adjourned.